Right, good afternoon. I think feedback. Does everybody have feedback? Yeah, okay, it may be me. Oh, seems to have gone away. Okay, well, Mr. Cullen, please continue with your submissions.
My Lord, I'm grateful. My Lords, my Lady, I was just going to invite your Lordship to look at supplemental bundle, tab 31, starting on page 348, just to go through an illustration of a transaction for the user, first of all, accessing a station site directly, and then I'm going to contrast that with what happens when the user accesses it via Tunein. Page 348, one sees the Google search being carried out by reference to the search term radio station. That then at page 349 reveals various results. The first results seem to be aggregator type sites. The first radio station which comes up looks to be Radio London at page 350. And then if one drops down, one sees Heart Radio, page 351, and one can see that for the purpose of this illustration, it's underlined, indicating that the user has, for this exercise, clicked on Heart to see what happens. Heart was one of the category 1 sample stations, which I think is why that's chosen. And you can see the little hand by the radio on Heart London Radio indicating that's where the browser is. And then one sees the results of that pressing of that button at page 352, where the user ends up at the Heart homepage, being presented a Heart advertisement for Zing Flowers. And on that Heart homepage, the court will see in the top right-hand corner there is a button saying listen. And that is what one must then press in order to receive the station stream. And that is what, for the purpose of this exercise, has then happened. The user presses on that listen button, and what happens next, one sees at page 353, that user is fed, although it's not apparent from the screenshot, but I can tell you, Lordships, and this what the evidence was, the big dark block on the left-hand side of page 353 is an audio-visual advertisement. It's an audio-visual pre-roll advertisement being fed to the user before he or she gets to hear anything that is being broadcast by Heart. Once that audio-visual advertisement is played out, the user then gets what one sees at page 354. In the left-hand side, one sees the Heart Radio media player, which tells the user what's playing, and beneath that has an advertisement, a Heart advertisement within the media player. And at the same time, the user remains on the Heart home page and receives the visual advertisement that is there displayed. That can be contrasted with what happens when the user seeks to access a station via Tunein. And for that, one can go back to tab 30, page 340. And there, the search term that's used is more focused in this example. So the user simply put in classic FM. At page 341, one sees the result of that. Various classical radio stations are listed, classic FM being the top one, classic FM from Lagos, Nigeria next, ABC Classic FM, ABC Classic 2, music performed by Australian musicians, So various stations from various parts of the globe are listed as search results, and one sees a UK advertisement, UK targeted advertisement on the right-hand side. And then if one turns to page 342, the court will see where one goes if the Classic FM button is pressed, and one goes to the Classic FM page on Tunein, noting that on the right-hand side there's again a UK targeted advertisement, and in the media player at the bottom screen of the screen there on page 342, the court will see it says advertisement, your content will start shortly. And what's happening there is that the user is being played a Tunein pre-roll advertisement. So the user has avoided Classic FM pre-roll and is getting the Tunein pre-roll instead. And then at page 343, the Classic FM stream has started. The user is still on the Classic FM Tunein page and is still having displayed to him or her the Tunein display visual advertisements. Now, my lords, my lady, what this means, and as the judge found at paragraph 10 judgment, the advertisements that the user is seeing, he or she is seeing on Tunein's site at the expense of the advertisements that he or she would otherwise see if visiting the underlying station site directly. That means that the underlying station is being deprived of revenue because it's not getting the ad impressions which we would otherwise get. And of course, in any world in which rights holders are paid a proportion of revenue as their royalty, as for example the UK is, as the court will know, and no doubt most other jurisdictions, then the revenue share received by rights holders will be consequently diminished. Now, my learned friend yesterday said, well, actually none of this matters and it all works to rights holders' benefits. Witness the fact that one station, there was evidence before the court, objected to being delisted because traffic might be driven to the station by Tunein. Well, one station doesn't prove a point, but my lord, even if my lords, my lady, even if one takes that at face value, in a world where Tunein exists and millions of people use it, stations might well feel that they have no option but to be on Tunein to get the benefits that they derive. But what one can certainly infer is that they would prefer that users access their streams via their own websites, because that's how they will get ad impressions and advertising revenue. What Mr. Howe's submission in this context really serves to underline is the crucial role played by Tunein in providing access to these stations. If it's the case that stations feel the need to be on Tunein to get listeners, that gives the lie to the submission that Tunein makes more generally, that it just provides a means, much like Google, of getting to their sites. If it's the case that it drives traffic, that's because Tunein provides an indispensable role in getting people there. It's perhaps relevant to note in this context one of the questions which arose yesterday in relation to revenue sharing and whether stations benefit from the revenue that Tunein generates. First of all, the vast bulk of stations, if they have a contract at all, will be subject to the standard terms and conditions which don't provide for any revenue share. There are some agreements which do, and these relate to some of the sample stations. Just to give your lordships and your ladyship a quick run through that. Tab 47, page 431 in the supplemental bundle. Is the agreement relating to country 104. If the court has that. While we've got this open, it might just be useful to look at the, in inverted commas, warranties for the purpose of this agreement. It's one of the things that are referred to in the judgment.
Excuse me, Mr. Cullen, I'm not sure I'm on the right page. Could you give me the reference again, please?
It's supplementary bundle, page 431, tab 47, my lord.
Thank you.
And so the, so far as relevant to the warranties point, which I'll come back to, but it may avoid us having to look at this again later. If the court picks it up about a third of the way down within clause 1, there is a sentence beginning, company is solely responsible for the licensing of company content for public performance, including when a user accesses company transmissions from company computer servers, etc. Now, when we come to talk about the warranties, in this form of agreement, that is what I understand Tunein to rely on as a warranty. But my lords, my lady, in relation to this revenue point, the court will see clause 3. Company will retain, and then we don't know what the figure is, it's redacted, it may not matter much, but what one sees is that the broadcaster is in effect retaining the revenue it receives from audio advertisements broadcast within the company content accessed via the Tunein service. So, as it were, in-stream advertisements, that's all kept by the station. And then there are pre-roll and display advertisements are defined, and net revenue is defined, and then your lordship will, your ladyship will see there's a revenue sharing arrangement. Again, the details of it we don't know. So it is possible that the radio station claws back something, but at all events, Tunein pockets its share. If one then turns on, one sees a similar agreement with another one of the sample stations, tab 49, page 435, in the same bundle. This is the station called Deutschland Funk. It's in similar form, the agreement. It has a similar allocation of responsibility for licensing in clause 1. Here there is no revenue sharing arrangement of the kind we saw in the last agreement. Just to follow the point through and complete it, just to give the court the run through, tab 52, page 474, is the equivalent agreement with another sample station. This sample station is called Mix Megapol. The same allocation of responsibility for licensing and a revenue share in similar form to the one we saw in the first agreement. And then in the next tab, here we're at page 476, the agreement is in slightly different form. Here the station's, I'm sorry, I should have said is Sky Radio hits. The agreement is in slightly different format, but the terms are pretty much the same as what we've seen. Clause 5 has the allocation of responsibility for licensing at page 477, and one has some revenue sharing at clause 7. So the court will see that in some of these cases there is revenue sharing, in some not. As we understand it, anyway, these sorts of bespoke agreements are the exception rather than the rule, and most stations will be, as we understand it, if they're subject to any sort of agreement at all, they'll be subject to the standard terms, which one agrees, in inverted commas, by ticking the box on the website, and they don't contain any revenue sharing at all. My lords, my lady, the very fact of entering into these agreements, the kind we've just seen, is inconsistent with the characterization of a service of the mere provider of links, or indeed the mere provider of physical facilities, to use the words of the WIPO agreed statement in recital 27 to the directive. Tunein is a content provider and not a provider of mere links, and indeed Mr. Justice Burst's finding in paragraph 130 that it is not even a provider of links like the defendants in the Svensson and the GS Media cases is significant, particularly in a context where my learned friend seeks to say that those decisions are wrong. I'm going to return to this, but what Tunein does is far, far broader than anything that went on in either of those cases. And this is further illustrated, as one sees in paragraph 129 of the judgment, by the fact that Tunein itself sees its competitors as being other music services. Again, looking at the bundle, tab 28 in the supplementary bundle, this is page 320. There are other examples of this, but we only need to look at one. It's an agreement with Global Radio Services, that's a UK radio group. The nature of the agreement is one whereby Global Radio is going to sell advertising inventory for Tunein, and one sees that at page 321, where the services that the Global is to provide are set out. So it's selling Tunein advertising inventory. And then at clause 3, one little c on page 322, one sees on or before the 15th day of each calendar month, Tunein may provide company via email with a list of advertisers whose products and services directly compete with Tunein's products and services, and therefore may not purchase inventory from company or run ads on the Tunein service during the following calendar month. If company does not timely receive the restricted list, it will be deemed to continue in effect. And that list one sees at page 330, and a lot of the names on it will probably be familiar to the court: Spotify, SoundCloud, Amazon Prime Music, Google Play Music, YouTube Music. These are all, and this was in evidence, services which are licensed by rights holders. To the extent that the court isn't familiar perhaps with some of these, the court can look at Mr. Sternberg's first statement, paragraph 29, tab 16, page 241 in this supplementary bundle, where Mr. Sternberg describes what some of these services do and expresses the concern about the distorting effect that is created by the fact that Tunein claims not to require a license, whilst its competitors take licenses and pay for the rights. Now, my lord, my lady, one of the reasons why Mr. Howe seeks to persuade the court to adopt this reductive approach to his client's service is so that he can suggest that he's client service is really just a search engine on all fours with Google, and therefore cannot be liable. Now, the first point to make about this case isn't about the liability of Google or other search engines. Some rights holders, newspaper publishers, might have things to say about that, for example, in relation to Google's news service. But the court isn't concerned with that. It's not a proper approach for the court to start with Google as a paradigm of innocence, and then draw a comparison from there. As the cases often show, it is a commonplace for wrongdoers in these sorts of cases to say, well, what I do is just like Google. One sees that, for example, in Newsbin, just for the court's note, I won't go to this now. Newsbin, Parrot 2, tab 52 of the authorities, page 1344. And to similar effect, the defendant in the Cooper case in Australia, paragraph 40, tab 79, page 2227, where someone who is providing search facilities for illicit content says, well, I'm a search engine, what is the problem? The assessment that is required is not like that. And certainly in this case, the assessment that is required is to be carried out by reference to the applicable principles, which I'll come to, and not by reference to Google. But in any event, Tunein is clearly distinct from Google. And one sees that in the judgment of paragraph 128. Just to make some of the points in this context, a general search engine such as Google is essentially neutral as to the results it produces, as characterized in the thumbnails case in Germany. Access by a search engine, and this is quoting from paragraph 61, we can look at it if the court would find it helpful, but I'm not going to do more than refer to the little phrase I'm now going to read out, that's perhaps unnecessary. It's tab 89, page 2825. But there, the German Federal Court said access by a search engine is not done such that individual hyperlinks are set to certain other websites in a deliberate and purposeful manner. By contrast, that is precisely what Tunein does. It does not crawl and scrape the internet generally and to allow users to search the results of that general internet trawl. It's collected a database of a particular type of content, that content being streams of simulcasts and webcasts. And I emphasize streams. It is not even crawling to create a directory of station websites, as Google does, as we shall see. It is specifically creating a database of streams. It then indexes, categorizes, recommends, and does all the other things with those streams, as described earlier and as described in the judgment. And it gathers the metadata as to the particular content being played at any one time and supplies that to users. It enables users to search by reference to artists and all the rest of it. And from the user's perspective, he never leaves Tunein's site. Linking in that context has nothing to do with information location to gain access to other sites. It is all to do with providing the content to the user by Tunein. By contrast, a Google search yields a neutral selection of results, and in order to access the reference content, the user, as we've seen, has to click on the link and go to the referenced site. There is no ability for a user to search by reference to the content being played by any station, precisely because Google does not gather data about the content being played by stations, because it doesn't gather data about streams. Google does not link to station streams, and it does not provide access to the copyright content in issue in this case. It only links to station websites. And just for a further illustration of this, my lord and lady, tab 59, again, supplemental bundle, provides the comparison at page 504 to start with. Now what this is, at page 504, is a Google search for classical music radio. First of all, just to note one point, your lordship and ladyship will see at the top of the page a list of cards, stations. My learned friend yesterday suggested that if you click those, you get taken to the station website. That's not correct. What happens, as one sees if one flicks forward to page 515, at page 515, one can see that the BBC Radio 3 card has been clicked because it's got a blue line underneath it. And the effect of clicking on BBC Radio 3 card, as your lordship and ladyship will see in the search box above that, is that it converts your search term to a search for BBC Radio 3. So those cards are merely effective to convert the search from being a general search for classical music radio. It converts the search term to the particular station which is on the card. So if you click on those, you stay on the Google site. That's a point of detail. Going back to page 504, one sees the various search results listed out over 505 and 506. Some of them are radio stations, some of them are other things, some of them are Tunein. As we've already seen, none of those will take you, well, none of those link to a station stream. They all link to another website. And if one wants to access a stream, one would have to go through a further process. By contrast, the Tunein search for the same search term starts at page 507 and lists out 508 and following various classical music stations from various parts of the world, each of which give then direct access in the way we've already looked at to the stream. In comparing the two, the results are different, the access is provided in a different way, the user experience is entirely different, and the economic impact is entirely different. I'm now going to move on to the question of targeting, which I'm taking in a slightly different order from a learned friend, but I'm following the order that the judge took it in. And that's a logical order because targeting is critical to this, as I hope I've made clear in my opening remarks. Targeting comes into this at a number of points. It's relevant, first of all, to, as it were, the jurisdictional question as to whether there's a wrongful act taking place in the UK at all. And for that purpose, the communication to the public has to be targeted at the UK. It is also relevant, as we'll see, and this comes back to a point raised by my Lady Justice Rose, when one comes to consider the question of the new public. And the question of the new public, as we know, concerns what public was taken into account by any prior consent. That also involves issues of targeting, as we'll come to. But the prior question, in a sense, is whether if there's a wrongful act being committed here, there must be a communication targeted here. Insofar as one is considering Tunein's liability for communication to the public, that question must be are the links targeted at the public in the UK? And that is what the judge was considering in the relevant passages of his judgment at paragraph 16 through to 34. He was considering there what I described as the jurisdictional question. That, because one is looking at whether Tunein has committed the wrongful act, requires assessment of whether the links provided by Tunein are targeted at the public in the UK. And as I understand it, that way of looking at it is accepted by my learned friends. To consider that, the principles, I think, are not in dispute, and the judge's legal analysis is not queried by my learned friends. That is to say, it's an objective question whether the links are targeted at the public in the UK, but subjective evidence can be relevant and may be determinative. It can include relevant factors, can include the number of visitors, language, advertising, and explicit references to the UK. There is one potential point at issue in relation to automated advertisements. That's to say, advertising placed by automated platforms such as Google Ads, because the judge found at paragraph 24 that that didn't matter, because objectively they appear to be targeted at the UK. My learned friends, I think in the notice of appeal at least, dispute that, but the way the judge dealt with that was entirely in accord with Court of Appeal authority. If your Lordship and Ladyship look at the Argos case, that's tab 27 of the authorities, page 343. This was a case involving the well-known UK retailer Argos and an American company which, happily for it, found itself getting a lot of misdirected traffic to its website, and it took advantage of that by, in fact, turning its website into a billboard for advertisements, and thereby monetizing the UK users' mistakes. I'm putting that in a tendentious way, which no doubt the defendant in the case wouldn't have liked, but I don't think it matters for present purposes. And picking it up at paragraph 61, page 367, the Court of Appeal agreed with Mr. Mellor it's wrong to ask whether the whole website or even the individual pages fall in the circumstances of this case. That is because there it was a trademark case, so the particular question that needed to be asked was about whether the advertisements were targeted. Of course, in our case, the question is whether the links are targeted. And then paragraph 62, the question posed by Mr. Howe's argument is whether the targeter is Google and its advertisers or ASI. The judge did not make any finding that the average consumer would be able to come to a conclusion about who was selecting the ads for display on the website. It would all depend on context and expectation. And the consumer would think that some were selected or at least influenced by ASI. Mr. Mellor submitted, and I agree, there is an unreality in ascribing to the average consumer a conscious deliberation about who is targeting the ads, when the two events on which he relies occur very quickly and necessarily without much thought. Quite apart from this, the purpose of the targeting inquiry is to determine whether the act complained of is the use of the sign in the course of the trade in the United Kingdom in relation to goods or services, etc. And then picking it up at paragraph 64, it is true that Google ultimately has control over what ads appear on ASI's billboard. The right conclusion from that is that Google had a role in causing the ads to be targeted at the UK. Nevertheless, the consequence of the selection of those ads was that they appear on ASI's billboard, which thus became targeted at UK customers. I think the right conclusion is that both Google and ASI were targeting the ads in the UK using ASI's billboard. I therefore reject Mr. Howe's argument that it was Google and not ASI who was targeting. So that is Court of Appeal authority supporting the judge's approach, which is to say it matters not whether the ads are targeted by an automated platform. In any event, it doesn't matter because one has bespoke pre-roll advertisements, as we've seen, which on any view were targeted, as the judge found, paragraph 25 of the UK. Now, what Mr. Howe, I think, seeks to say is that, well, he accepts that the whole site is targeted, the site as a whole is targeted in the UK, and he accepts that some of the links, the UK station links are, but I think he says others are not. With respect, that is a hopeless proposition if one simply looks at some illustrations. And we've seen some already, but just to look at others, tab, this supplemental bundle, tab 16, I'm sorry, that's a bad reference. Tab 26, I'm sorry, page 301. This, your lordships and ladyships should have a search for Ed Sheeran. This illustrates what happens when one types in Ed Sheeran. And at the bottom of that page, the search results. And one can see that they begin with Stray FM. Then one has top music, l'esprit pop rock, I think it says. At all events, it's in French, and presumably a francophone territory is its home. And then one sees another foreign station below, etc. Now, for the person Malone and Friends argument, he seems to suggest that, for example, Wessex FM, which one perhaps can safely infer is a UK-based station, that link is targeted at the UK public. The foreign ones aren't. Of course, the user of this won't know whether Stray FM is a foreign station or not. I tell you, the court, that it happens that it is. But of course, the user doesn't know that. As far as he or she is concerned, they are targeted equally. And if one goes over the page, these results show what happens when one clicks on these links provided. First, at the top of the page, the user has clicked on Stray FM and can there see that the station is playing Galway Girl by Ed Sheeran, and one sees a UK targeted advertisement on the right. And then below that, that's what one gets if one goes to the top music station page. That's the francophone one, but it's pretty much indistinguishable for all material purposes from Stray FM in terms of what the user is going to think about being targeted. He or she is still getting UK advertisements, etc. And one sees a similar phenomenon at page 303 in relation to the search for a band called Clean Bandit, where one sees various results. The first one is Top FM. You can see below it's a Belgrade station, and the station page is displayed to the user alongside an advertisement for a dress starting at £5.99. Now, the ordinary user of this site is not going to have any inkling that some of these links are targeted at him or her while others are not. They are all targeted at English users equally. In Malone and Friends' written argument, he takes or seeks to make play of the absurdity, as he would have it, of an idea that an obscure Mongolian station would be targeted, or a link to an obscure Mongolian station would be targeted at UK users. Now, one can see behind tab 58, page 500, that is precisely what happens. This is the Mongolian station that he picks on. This is its station page. Interestingly, the Mongolian title is transliterated so that people who aren't familiar with Mongolian script can read a name for it, MGL Radio FM 88.3, and the advertisements which accompany it are for recitals at the Barbican and some sort of LinkedIn ad service, but clearly UK targeted and similarly over the page. So no UK user is going to be able to draw the sort of distinctions that the learned friend suggests he or she would. One can also look at the fact that of the 6,000, the top 6,000 UK stations by listenership, 80% non-UK stations. That appears in Mr. Grant's witness statement. Just for the court's reference, it's tab 15, page 224 of the supplementary bundle. I don't think we need to go there. Then I've already referred the court to the Spin the Globe feature, whereby foreign stations specifically are targeted at UK users. And indeed, that is Tunein's unique selling point, as described by its CEO in supplementary bundle, page 28, tab 6. The whole point of Tunein is that it puts a global radio in everyone's pocket. The fact that UK audiences listen to foreign stations is exploited by Tunein as part of its commercial offering. One can see that still in the supplementary bundle, tab 54, page 480. And just to talk your lordships and ladyships through this, this is an exchange of emails between MAP, who are sell advertising effectively for Tunein, between Molly Blatchley Lewis of MAP and the ad ops person at Tunein. And what it begins with, right at the bottom of page 480 and going over to 481, could you please let me know UK audio pre-roll avails at availability for Hindu and Sikh stations for 10th to the 23rd of October, and then narrow these availability down to the following regions. And I perhaps should have noted the subject heading, which is Diwali avails. So what is being asked for here are stations listened to by people in these towns to enable targeted adverts to be sent to them. And the answer comes, we can definitely provide you with this. However, since it's a small bucket, we had to pull all of the UK, otherwise it would be extremely minimal and unsubstantial. For those 2 weeks, we have a few options we can accommodate, etc. And one sees the station lists that are supplied. So these are stations against which it will, they will sell this sort of targeted advertisements to get advertising to a particular section of the UK public. By reference to the stations one sees at page 483 over to 488, and we don't know for certain where these stations are based, all of them, but one can reasonably infer that they are most, if not all, foreign stations, and indeed one of them was one of the sample stations, as it happens, at page 487, capital FM, the second one from the top of that page is Bangladeshi station. There is a similar document at page 4, or exchange at page 489 in the same bundle behind tab 5, where, again, picking it up towards the bottom of the page, we've had a brief which seems like a perfect fit based on past campaigns targeting international citizens of the UK. The potential client wants to target Polish, Romanian, German, American and Irish people living permanently in the UK, and therefore provides information as to the listenership of the relevant stations from those countries. And then further up the page, I forgot to mention we require Chinese information too. And then the answer comes, attached are avails and unique for users and UK listening stations based out of the countries you requested. I also included the top 25 stations for each country. And one sees the weekly avails, unique listeners at page 491 for the countries concerned. And then a list of the top 25 stations for each one, including, incidentally, Deutschlandfunk, the sample stations, page 492. So what this indicates is certainly Tunein's intention to target foreign stations at UK users, and obviously the UK users who as a result receive advertising will objectively be targeted, and certainly he or she will regard themselves as being targeted and will correctly regard themselves. So, my lady, the idea that one can in any way draw a distinction between the various hyperlinks for targeting purposes is hopeless. The judge was entirely correct to find that all of these stations are targeted by Tunein to the public in the UK. I will come back to that when we consider the new public criteria, but at this stage, in terms of the jurisdictional point as to whether a wrongful act is committed by Tunein, the position is clear. Now, I'm now going to... Yes, my lady, that is right also, and that's the judge's alternative finding when one gets to authorisation, because as the step before authorisation, one has to consider whether the stations commit a wrongful act as well. And my lady, yes, they do, because they go onto the Tunein service, they either allow themselves or they agree. According to my learned friend's case, the court should approach it on the basis that they all sign up to the terms and conditions effectively and agree this. And as we've seen from those terms and conditions, what Tunein is effectively saying by them is sign up to my service and we will enable you, we will let you be targeted at our global listeners. So the stations, I'll come back to this when we get to that point, but just to give the ladyship a heads up, the stations, in allowing that to happen, are effectively allowing their streams to become targeted at the UK public via the Tunein service. And that is a wrongful act by them.
Can I ask a question about that? Sorry, Mr. Counsel, I think you need to mute. So I appreciate your point that in the case of the stations which sign up to be presented by Tunein, in accordance with the terms and conditions, they are actively seeking that Tunein should present their station to Tunein's global audience. I understand that point. However, why does that amount to targeting the UK? Why is it not simply making available their station to the entire world?
targeting the global world, the entire world, they know, and it is the case that, as part of that world, the UK is one of those countries that Tunein targets. And so they must be taken to know that by agreeing to be on the Tunein service, the result will be that, amongst other countries, they will be targeted at the UK. If your lordship is with me, if the court is with me in relation to where Tunein is targeted, then the inevitable consequence of becoming a part of Tunein, if I can put it like that, is you thereby become targeted at the UK.
So do I understand your submission to be that it's parasitic? Namely that because Tunein service is targeted at the UK, and because the stations sign up to Tunein, therefore they are targeted at the UK. And perhaps one could draw a contrast. If we imagine a country in the world where Tunein is not targeted, let's take Vanuatu as a random example, because there's no ad targeted at Vanuatu, etc., etc., etc. So you can't say that Tunein's service is targeted at Vanuatu. I assume in those circumstances you would accept that by parity of reasoning, the station in Mongolia is not targeted at Vanuatu either.
Well, that must be right. That must be right. But the point for the purpose of getting ahead of oneself, the point is, my lord, if one has a service such as Tunein, which is effectively a form of distribution service, and certainly that's the way I invite you to see it, and if that service is targeted at the UK, then if I as a station sign up to it, it must follow that I am inviting my streams to become targeted at the UK.
What was the position before 2011 when they just randomly crawled and added streams to their Tunein service without any involvement of the radio stations?
Well, my lady, there the analysis might become more difficult in fixing the stations with the necessary knowledge. And in a sense, that is why Tunein itself must be liable, because they are the only ones who could be said to have been liable, to have caused the retargeting.
But I thought you said that it's an objective question whether something is targeted. So what is the knowledge then that you accept is required by the stations before they are being targeted via Tunein?
My lady, in circumstances where they know that they are on Tunein and the Tunein is being targeted, we say that is absolutely clear. A fortiori, where they've actually agreed. I would have to accept, my lady, that where there are stations which don't even know they're on there, the position might be a bit more difficult.
Well, but presumably as far as the user thinks, looking at all those screenshots that you showed us, the user wouldn't be able to tell any difference between those stations and the other station.
That is entirely right, my lady. And so it may be that the answer is for the user, simply because he or she is seeing it through Tunein, they are certainly all thereby targeted. The question is maybe who is responsible for the targeting. Now we say on any view Tunein is, and certainly any station which knows that it is on the Tunein service, in effect has adopted that targeting.
So it becomes a question of who's the primary infringer and who's the accessory.
That's one way. My case is that they're both primary infringers.
Yeah, well, that's the point we're jibbing at. One can understand the proposition that one's primary and one's accessory It's a bit more tricky to say they're both primary.
My lord, no. Your lordship himself in EMI accepted that where one has an act of communication, two people may be responsible for it. And where one has an act of communication, as in this case, let's take a station which is, to remove sort of the grey area, the station which has signed up to a bespoke agreement. If the activity of both is an ingredient to the act of communication, then there is no reason on earth to find that they should both not be liable. The station is liable for its part. It communicates the content, etc. But that does not rule out also that that Tunein, by its involvement, is also committing an act of communication. It is not either or. One could certainly have a case, and perhaps we'll look at it in due course, but in EMI, your lordship certainly held this. The situation where for any given act of communication, two people will be responsible. My lord, one could see it, for example.
Yeah, I think we're going to need to look at the circumstances of that case. No, I mean, don't go out of your course, please. Come to it later when convenient.
Well, my lord, just to finish it, if one looked at, for example, the situation in Pirate Bay, where you have BitTorrent users who are making content available, and this appears in the authorities, the seeders and will be liable for communication to the public, the people who allow their computers to be used to provide the bits. But so also will the platforms like the Pirate Bay. It will be the same act of communication. Two actors can be liable, but we may be getting ahead of ourselves, and we'll perhaps come back to that. I was going to move on then to communication to the public itself, and deal with what we say about the approach to that. I'm going to try and do this without taking the court to too much authority, because the court has already seen some, and a lot of the propositions are pretty clear, given the number of references there have been. The basic propositions we rely on set out in paragraph 30 of our written argument. And just to run through them briefly, first, the principles begin with the need to construe the communication to the public right broadly to provide a high level of protection, and we set out the various recitals we rely on. I'm going to come back to Raphael, which we refer to there specifically, and Renkoff. I don't think I will be looking at, but we see what's said there. Just in relation to that first paragraph, Arnold, the Master of Rolls yesterday suggested or threw out the possibility that where one is concerned with internet exploitation as against more old-fashioned analog broadcast forms of exploitation, there may perhaps be a different balance to be struck, or different considerations, or I can't remember precisely how Lordship put it. What one doesn't see is anything like that reflected in the recital. The same need for a high level of protection to protect the ability of authors and creators to obtain an appropriate reward applies online and in more old-fashioned forms of exploitation. So these sorts of propositions that one sees there, they sound like motherhood and apple pie, and they're important, and I don't want to labour them, but equally the court cannot lose sight of them. My Lord, Lady, Next, the concept of communication involves two cumulative criteria: the act of communication and the to a public. Sounds actually hauntingly like Mr. Howe's formulation of the way it should be. Turns out that's the way, in fact, it is. And then paragraph 33, the concept of communication requires an individual assessment, taking into account several complementary criteria, etc. All must be applied individually. I've given there a reference to CJEU. For each of these propositions, we could have referred to 12 authorities. We've not done so because obviously the court doesn't like that. But these are not by any means isolated instances of these being set out as relevant provisions. 30.4, the work doesn't need to be actually transmitted, a point which Mr. Howe accepted today. That's from one of the film surveiller. And then one gets to the particular criteria which can be relevant. The first one is, in a sense, the core of this. This is a formulation one sees, not always precisely with these words, but this is a formulation which is at the heart of all of this. It's the indispensable role played by the user and the deliberate nature of his intervention. The user makes an act of communication when he intervenes in full knowledge of the consequences of his action to give his customers access to a protected work, particularly where
I've got a question about that. As you rightly observe, one sees that statement in either that form or slightly differing forms made repeatedly in a number of the cases. And my question is this: upon analysis in your submission, does that statement require to the question of whether there is an act of communication at all, or does it in truth really concern the question of who is the person making the act of communication?
My lord, it's the latter, if I may say so. And this also gets one, in a sense, it's the answer to my learned friend's point about there being a need for a transmission. In this case, there's obviously a transmission because content is being played. The question is who is responsible for that transmission. And this is the test that the court commonly applies. My learned friend's approach, as he would want it to be, and really one's getting way down the line of the argument here, but just so I can address it head on now. His approach seems to be that the only person who can be liable is, in effect, the transmitter. That there can only be one person liable for any act of transmission, and it can only be the person, in effect, from whose servers it emanates. What my learned friend is urging upon the court is effectively a variation, or perhaps not even a variation, just a different label to what in the US is called the server test, or the server theory. It's not popular in the US, and it's certainly not EU law. So your lordship, with respect, is quite right that one has, in any case, well, there may be cases where it's in doubt whether there's a transmission or not, but for all events, in all the cases the court's considered, there's clearly a transmission, and there's clearly a transmission here. Content is going from A to B. The question is who is responsible for that, and that question is determined in accordance with the formulation that one sees there. My lord, my lady, then passing down, still in paragraph 30, one has the relevance of profit making, and this is Lord Hoffman's follow the money, and the European Court also considers that to be relevant for we would submit obvious reasons.
So I've got a question about that. In the early case law, the suggestion appears to be that that is relevant to the question of whether there's a communication. In the later case law, the suggestion appears to be that it's relevant to whether it's a communication to a public. Is it your submission that it's relevant to the first question or the second question or both?
Both. It is one of the reasons why these factors are described as complementary, interdependent, etc. And one can see in the cases it sometimes plays in at different points, as your lordship has indicated.
But as a matter of logic, why? One could understand why it would be relevant to the question of whether it's to a public, because if it's profit-making, then it's unlikely to be directed to a private circle or family circle. As soon as you're profit-making, you're going outside that. And so you can understand the relevance of it to the public. But why is it relevant logically to the question of whether there's a communication?
Because, my lord, it has a bearing on the nature of the act of intervention. That if the act of intervention is being undertaken from a profit-making motive, that informs the court as to whether, to pick up the words, he is intervening in full knowledge of the consequences of his actions to give his customers access to a protected work. Where the relevant actor is not acting for profit, is acting, as it were, recreationally, then that will impact on that question. But it may be, my lord, that it has more relevance to the subsequent question. Well, we would submit that it comes in at both points. Now, my lord, and then, my lady, we then have that it must be to a public, and in particular, as we know, to a new public. I'm going to come back to the new public question, but first of all, look at the prior question about what is an act of communication, and just look at some authority on relation to that. And starting at the start with Raphael, which I think it is worth looking at. It's at I'm sorry, let's find the reference. It's at tab 70, authorities bundle 3. And it's the case involving the playing of televisions in Spanish hotel rooms.
What's the page number, please?
I'm sorry, it's 1933 is where the report starts. And one can pick up the relevant part of the decision at page 1956. At paragraph 36, the court notes the need to interpret it broadly to establish a high-level protection, etc. And then at paragraph 40, it should also be pointed out that a communication made in circumstances such as those in the main proceedings constitutes, according to Article 11 bis of the Berne Convention, communication made by a broadcasting organisation under the original one. Thus, such a transmission is made to a public different from the public at which the original communication of the work is directed, that is to say, a new public. Now, pausing there, I said earlier that the question of targeting was also to the new public question. I'll develop this in due course when we get to it, but I invite your lordship and ladyship to note the word directed, effectively a synonym for targeted at that point. The court then goes on, as is explained in the guide to the Berne Convention, an interpretive document drawn up by the WIPO, which, without being legally binding, nevertheless assist in interpreting that convention. When the author authorises the broadcast of his work, he considers only direct users, that is, owners of reception equipment, who either personally or within their own private or family circles receive the programme. According to the guide, reception is for a larger audience, possibly for profit. A new section of the receiving public hears or sees the work, and communication of the programme via a loudspeaker or analogous instrument no longer constitutes simple reception of the programme itself, but is an independent act through which the broadcast work is communicated to a new public. As the guide makes clear, such a public reception.
So, although Mr. Howe didn't put it quite in these terms, on his argument, this is where the Court of Justice goes right off the rails, right at the outset. And they go off the rails at the outset in two respects. First of all, they've got their eyes on the wrong treaty, because what they should be looking at is Article 8 of the WIPO Treaty, not Article 11 bis of the Berne Convention. Secondly, and more fundamentally, they're looking at the 1978 guide to the Berne Convention. What they ought to be looking at is the 2003 guide, not only the Berne Convention, but also the WIPO treaties. Thirdly, they're misreading what the 1978 guide says anyway.
Well, my lord, I don't know if you want me to respond to those points now, to deal with it later. Those are my learned friend's submissions in relation to why the court has gone wrong. At the moment, I'm dealing with what the court has in fact said. My lord, perhaps I can come back to that tomorrow. But at all events, at this stage, this is the approach the court goes down. And paragraph 42, the clientele of the hotel forms such a new public. The transmission of the broadcast work to that clientele is not just a technical means, etc. On the contrary, the hotel is the organization in full knowledge of the consequence of its actions. Here one gets the first iteration of that sort of language. To give access to the protected work to its customers. In the absence of that intervention, its customers, although physically within that area, would not in principle be able to enjoy the broadcast work. And then paragraph 43, they note that it's not decisive that customers might not actually have watched the television and had access to work. And then they go on to say that it's relevant that the use or the provision of the televisions is for profit-making purposes. As my Lord Justice Arnold indicated, the court has relied there on the guide to the Berne Convention. Just to pick up that reference in full, one sees it set out in the Advocate General's opinion at page 1945 of the bundle. Sees there in relation to Article 11 bis what is said in the WIPO guide specifically about this, and in particular at letter G, just towards the bottom, although by definition the number of people receiving a broadcast cannot be ascertained with any certainty, the author thinks of his license to broadcast as covering only the direct audience receiving the signal within the family circle. Once this reception is done in order to entertain a wider circle, often for profit, an additional section of the public is enabled to enjoy the work, and it ceases to be merely a matter of broadcasting. And then, I won't go through this in detail now, but just for the court's note, paragraph 54 through to 57, the Advocate General considers somewhat greater depth the relevance of the profit-making motive, as it were. And it's, I think, to come back to my Lord Justice Arnold's point earlier, it's fair to say that this discussion is probably couched more in terms of the consideration of the public. But it's also fair to say, in relation to this whole decision, is that it's at this stage, being the first decision in the line, it doesn't divide up the two questions as they have become rather formulaically divided up in terms of, is there an act of communication? Is it to a public? Is it to a new public? Which is the way that the structure of the judgments has now become. in this first decision, one can see the court dealing with it in a somewhat more holistic way, but obviously underlying it, there are two separate questions. It assists for explanatory purposes to divide it out, and one can see where one does that. But one mustn't lose sight of the fact, and certainly in our case, the judge did not lose sight of the fact that it is, if you like, a holistic question. I'm looking at the time and I wonder whether it's a convenient moment.
Sounds very sensible. Mr. Cullen will resume at 3:20. Thank you. waiting for Lady Justice Rose. Here she is. Mr. Cullen.
The question for the judge below was carrying out an individualised assessment. Does Tunein intervene in a material way to give access, if I can use that shorthand? Now, looking at it at a reductive level, the provision of links, as my learned friend invites the court to do, the answer to that question is provided by the European Court in Svensson, which says that providing a link does constitute a material intervention. I don't intend to take the court to it at this stage. GS Media affirms that. Of course, in between, Bestwater said the same. Bestwater said, in effect, it made no difference that it was transclusion or a form of framing. Of course, that's starting from the point that a bare link, if you like, or a link that actually takes you to the referenced site is an act of communication, and so therefore the framing becomes all the more so. Then one has other cases following that, which are to the same effect. So Filmspeler, or Willems, is again provision of links. It may be said that it's, in a sense, at one remove, because the way in which the links were provided was by way of a device, as Mr. Howe showed the court yesterday. But it is nonetheless an act of communication. And then one has Ziggo, the case involving the Pirate Bay. Again, an act of communication. Mr. Howe said that decision was not surprising, but my lords, my lady, it's an important decision for this case, because we say that really what Tunein does is materially indistinguishable. The Pirate Bay does not provide any content. No transmission of content goes from the Pirate Bay to its users. What it does is provide a searchable directory with some other things as we'll come to. But it provides, the way that the technology works, is it provides torrent files which enable users to obtain, and it provides so-called magnet links, just another form of linking, to those torrent files. To that extent, the intervention, if you like, might be said to be less direct than Tunein's, since Tunein provides direct links, and moreover, it provides them in a way in which the user is kept on the Tunein site. If the court were to accede to my learned friend's invitation to find that linking can't give rise to liability, it will follow that a site like the Pirate Bay will similarly not be liable. My lords, my lady, it's perhaps instructive to look at Ziggo, and in particular one particular part of the court's analysis. It's in the authorities bundle. Behind tab 22, it starts at page 204. That's the Advocate General's opinion. The judgment starts later. What I was, your lordship and your ladyship have seen this, so I don't intend to go through it in detail again, but just to highlight in particular paragraph 38.
Sorry, can you let me have the page number again?
Sorry, it's page 228, my lord.
Thank you.
where the court says this: finally, the operators of the online sharing platform TVV cannot be considered to be making a mere provision of physical facilities. It's clear from the order for reference that that platform indexes torrent files in such a way that the works to which the torrent files refer may be easily located and downloaded by the users of that sharing platform. Moreover, it is clear from the observations submitted to the court that in addition to a search engine, or there's a search engine bit of it, but in addition, the platform offers an index under different categories based on the type of the works, their genre or their popularity, within which the works made available are divided, with the platform's operators checking to ensure that a work which has been placed in the appropriate category. In addition, the operators delete obsolete or faulty torrent files. Now, my lady, that is certainly mutatis mutandis, a description of Tunein's service. Indeed, Tunein goes further, because it, for example, provides curated recommendations and provides search facilities for content actually being played, and all the other various things, which means that the whole package that Tunein provides is much more sophisticated and user-friendly than the Pirate Bay platform, and moreover, the content is provided in a way which, as the judge held, makes it appear that the content is being provided by Tunein. Even in the specifics about the court noting the deletion of obsolete torrent files, etc., Mr. Howe explained today how Tunein in 2018 conducted an exercise where they went through their 120,000 streams as they then were, and removed about 20,000, I believe, of links to streams which were either no longer working or which didn't attract any listeners. So we say that really there is no material point of distinction between what Tunein does and what the Pirate Bay does. If anything, what Tunein does is a more significant act of intervention. It's also relevant in this regard to look at the English authority in this area, which my learned friend didn't take you to. First of all, one starts with consideration of this with the Newsbin case. We perhaps don't need to look at it, but Newsbin used a technology which was functionally very similar to BitTorrent technology. I hope I'm not doing any injustice to it in saying that. And Mr. Justice Kitchen, as it then was, found that Newsbin was nonetheless committing an act of communication.
Mr. Cullen, I'm afraid my computer crashed and I missed the last 60 seconds. I've come in on another computer. I don't know what I've missed, but I can pick it up on the transcript probably, but just so you're aware.
My Lord, I'm sorry, I didn't notice. But my Lord, I was just turning to the English authority in this area, and I've noted that, first of all, one has Mr. Justice Kitchen, some time ago in the Newsbin case, deciding that the operators of the Newsbin site, which use technology similar to BitTorrent technology, that they communicated to the public, although they did not themselves transmit any content. What they provided was a form of something equivalent to a torrent file to enable users to collect pieces of infringing content and put them together on their computer. One then has various decisions in relation specifically to the Pirate Bay and other BitTorrent sites, predating the decision in Svensson and indeed the decision in Ziggo, but where the English court, and in particular, Lord Justice Arnold, reached the same conclusion as the European Court some years before. One sees that in Dramatico, which is tab 32, page 590. I won't take the court to that now. To the same effect, and perhaps we will look at this, the EMI at tab 33, page 623. And why I take the court to this now is because a point that specifically arose a few moments ago in relation to the idea that there might be two people committing one act of communication. This was a blocking order application in relation to some sites, some BitTorrent sites called CAT, H33T and Fenopy. And I don't think we need to get too caught up in the thickets of it, but just if one turns to page 634, first of all, and one sees the heading posed before paragraph 23, do users of the websites infringe? So that's to say, people using the BitTorrent sites. And my Lord Justice Arnold, first of all, addresses copying, which we're not concerned with at this point in the argument here. Paragraph 28, he explains why he considers that users do indeed communicate to the public, and one sees the conclusion there at paragraph 42 on page 638. And then the court goes on to consider the next question as to whether operators infringe, and that is picked up under at the top of paragraph 44, and the court draws the analogy with Newsbin and finds no real distinction. And then at paragraph 46, I would add, I see nothing in Football Data Code Sport Radar to exclude the possibility that more than one person may be involved in an act of communication to the public. In the present situation, the communication to the public involves both the operators who provide the mechanism and the users who provide the actual recordings. So, two actors in one infringement. And so the conclusion is reached that they do, that the site operators, in addition to the users, commit the relevant act. To the same effect is the court's decision in 1967 limited at tab 24, page 263. Again, I won't take the court to that at this stage. Now, what my learned friend says about this is, oh, well, it's BitTorrent technology, it's different. Well, my lord, we don't accept that there is any relevant difference. But in the light of that, it's perhaps relevant to go on to consider some other technologies that have been considered by the English court that are relevant. First of all, my lords and my lady, if you look at FAPL behind tab 35 at page 681, this was an application concerning a site called First Row, and what First Row did was provide links to streams of sporting events. Those links were uploaded, provided by users. There may have been some element of doubt as to the extent to which the operators of the site might also have been involved in providing the links. The facts are described in particular paragraph 10, page 686. The judgment recites the rights that are in issue, and at paragraph 12, and then at paragraph 14, the First Row website is described. And what one sees there is that what is provided is a collection of links to streams, and when they are clicked upon, the user is taken, this is from paragraph 14 towards the bottom, the user is taken to a new page featuring a frame or window in which the live coverage then appears accompanied by advertising. And then paragraph 15, the streams that are indexed on First Row are provided by third-party streamers using one of a number of UGC sites. Paragraph 16, the penultimate sentence, just in case there's any doubt, it's recorded that First Row itself does not self-transmit any of the streams. They emanate from the UGC sites. And then the analysis begins at page 688. Do the operators, this is above paragraph 26, do the operators and users infringe copyrights? And the court then goes on at paragraph 31 to set out what was concluded in EMI, or at least to set out the questions that are relevant from EMI. My lord, my lady, perhaps the salient passage appears in particular at paragraph 42, 693. In the present case, the operators of First Row have intervened in a manner which, although technically different, is analogous to that of the websites under consideration in those cases being the BitTorrent cases. First Row aggregates together a large number of streams from a variety of streamers, indexes them for the convenience of the user, and provides a simple link for the user to click on in order to access a specific stream. It's true that the technical effect of clicking on the link is to direct the stream from the UGC site to the user's computer, but even so, the stream is presented in a frame provided by First Row. In all the circumstances, I consider that First Row is responsible for the communication, and then if that's wrong, they're jointly liable. Now, we say this is indistinguishable from the present case. It's the provision of links. First Row aggregates them, indexes them, etc. Again, if anything, what Tunein does is a more substantial act of communication for all the reasons that I've already presented to your lordship and your ladyship. And again, to much the same effect, Paramount in tab 44, page 1004, this concerned sites that provided directories effectively of films that could be streamed. One sees the description of the websites at paragraph 5. And it's recorded there that the mode of operation is broadly similar to that of First Row, and we say broadly similar to that of Tunein. They don't host the content. They ensure the content is comprehensively categorized, referenced, moderated, and searchable, etc., etc. And in this case, the court then, as we know, set out in paragraph 12 the relevant principles. Then the court noted the then outstanding reference in Svensson, and a description is given of what that involves at paragraphs 13 through to 22. And then the court refers to another reference of Seymour Entertainment. That involved a somewhat similar service linking to live ice hockey matches and the questions there posed. The court will see the questions posed in Seymour at paragraph 24, which effectively ask whether providing a clickable link is an act of communication. And as we've put in our written argument, and I won't go to it now, when one looks at the Seymour decision of the European Court, the questions relating to whether the provision of links could be an act of communication were effectively treated as answered by Svensson, and so those questions were withdrawn, and the court was only had to deal with what is question 5. At all events, having considered all of that, the court then gives its reasons, paragraph 31 and following, and at paragraph 32, my Lord Justice Arnold says, I've reconsidered this reasoning, that's to say the reasoning from from EMI, and then says, as the law presently stands, I adhere to the view the actions of the operators of websites like the one under consideration in FAPL amount to communication, more specifically to making those works available to the public in such a way the public may access them. I acknowledge it's arguable that the mere provision of a hyperlink is not enough to constitute communications to the public, particularly if the hyperlink is not directly to the source of the copyright work. I also acknowledge that it's arguable it makes no difference whether or not the source of the copyright work to which the hyperlink links is licensed by the copyright owner. I also acknowledge it's arguable it makes no difference whether clicking on the link results in framing. What the operators of first row were doing, however, went beyond the mere provision of links linking directly to unlicensed sources of copyright works. As explained in the passage quoted above, they were intervening in a highly material way to make copyright works available to a new audience. Now that reference to what is explained in the passage quoted above, one sees in paragraph, at the top of the page, where it's the reference in particular to paragraph 42, which I showed the court. And that is to say, it is not merely a question of providing a link, it is providing the aggregating service with the indexing, the organization, and all the other features that provide the convenience service. All of that goes in to the consideration of whether there is a material intervention. And with respect, that analysis is pretty much indistinguishable from what we've seen in paragraph 38 of CJEU. It's not just a search engine, it has all these other features. Of course, as it happens, following this judgment, Svensson actually decided that mere provision of a link is a sufficient act of communication. But my Lord Justice Arnold would have decided the case anyway on the basis in which he did. Now, if Mr. Howe is right, none of these sorts of services are committing the relevant act. We say that cannot be right. I'm now going to move on to the question of the public, which is the second question, whether the communication is to the public. In terms of numbers, there's no doubt here that it is to the public, in the sense that it is a sufficient number of people, it is outside of family circles and the like. The question is it to a new public? Now, when considering this, it's important to bear in mind the significance, the centrality of consent given by rights holders. The question is, as posed in the authorities, is it to a public taken into account by the rights holder's prior authorization? My Lord, my Lady, we say that means looking at the license where it exists. In some cases, the terms of the license will answer the question. In particular, where the terms of the license have territorial limitations, for example. That's our case. We say this is easy. In other cases, the analysis may be slightly more nuanced, either because one is seeking to imply a license or to ascertain by a matter of inference the scope of the license, or because the license is given in circumstances where the particular secondary use is targeting something different. And that's the Raphael case. But I'll come to that. But if I could just deal with, well, no, just to make that quite good in relation to Raphael. One of the points about Raphael was that the broadcasts were licensed by the broadcaster for that particular territorial footprint, if you like. The hotel was in Spain. The television broadcast had been licensed for broadcasters in Spain. And so one might, at a trite level, say, well, was that public taken into account? And one might you'd say, well, plainly yes, because they were broadcasting in Spain. And as we've seen, the European Court didn't address it in that way, because it approached it on the basis that that broadcasting license will only take into account users in family circles, in private settings. And if one starts rebroadcasting or broadcasting or transmitting in a different environment, a new license is required. And that is because one is considering the target of the original licensed broadcast, if you like. That, of course, isn't a complexity, we say, in our case, because in our case, the restriction on the relevant license, to the extent there is one, and I'll come to, is always going to be territorial, so it's very much easier to find who is targeted. But, my lord, my lady, I'll come back to that in a moment, but just to consider the authorities, and first of all to look at Svensson, because my learned friend's case is effectively that Svensson stands as authority for the proposition that if a work is up on the internet, there's basically a deemed consent worldwide for all purposes in absolute terms. And once it's there, that's it. The right is effectively exhausted. That's what my learned friend's case amounts to. My lord, my lady, we say that is quite wrong. And first of all, just to look at the relevant part of Svensson behind tab 19 in the authorities bundle. And picking it up at page 160, well, 162, one sees the court making the finding that there is a relevant act. And at page 163, the public question is considered. And the important finding that the court makes at paragraph 26 is that the public targeted by the initial communication consisted of all potential visitors to the site concerned, since given that access to the works on that site was not subject to any restrictive measures, all internet users could therefore have free access. Now, in the circumstances of that case, the people posting the work originally were effectively the copyright owners. It was a newspaper site and the articles were written by journalists. And one can see why the court approached it on the basis that the public targeted was all potential visitors, i.e. everyone. But it's important to note, echoing what we saw in Raphael, that the broadcast was directed at private people in their own homes. Here, the court is again using that sort of language to talk about the public being targeted is all potential visitors. That was explained in a subsequent decision of the European Court in Soulier, tab 72, page 1979. This was a case involving a proposed scheme in France to enable out-of-print works to be published, and it was going to be, in effect, a sort of compulsory scheme. It was very worthily motivated and was intended to generate revenues for authors, but the question that came before the European Court was whether it was lawful to impose such a scheme on authors, and the answer was no. The reasoning is set out page 2007 from paragraph 29 onwards. Again, we get broad interpretations, etc., being noted, and picking it up at paragraph 35, after the court has stressed the need for prior consent, the court then said this: nevertheless, Articles 2A and 3.1 of the directive do not specify the way in which the prior consent of the author must be expressed, so that those provisions cannot be interpreted as requiring such consent must necessarily be expressed explicitly. Must be held on the contrary, those provisions also allow that consent to be expressed implicitly. Thus, in a case in which it was questioned about the concept of a new public, the court held in a situation in which the author had given prior, explicit and unreserved authorization to the publication of his articles on the website of a newspaper publisher, without making use of technological measures restricting restricting access to those works from other sites, that author could be regarded in essence of having authorized the communication of those works to the general internet public. However, the objective of increased protection of authors to which recital 9 of the directive refers implies that the circumstances in which implicit consent can be omitted must be strictly defined in order not to deprive of effect the very principle of the author's prior consent. So what the court is there saying is that Svensson, in the particular circumstance of that case, was dealing with a prior, explicit and unreserved authorization. But the court goes on to caution the circumstances in which you can find such consent, particularly implicitly, must be very narrowly defined, because otherwise you are depriving the author of his essential right to consent or not consent. If, as we have in this case, any consent being limited to a particular territory because the license is limited to a particular territory.
How was that made when no
It's very difficult. It's very difficult to. I wonder if Mr. Cullen could use his microphone so we can Lady Justice raised the question.
Although it may be territorially limited, presumably the rights holders in these countries know that it is being simulcast on the websites. So if they allow, I mean, these websites are not prohibited by the rights owners, the radio stations' websites. So the rights holders know that their material is being transmitted via the radio station's website, and that can't be territorially limited unless it's geo-blocked, as Mr. Howe was explaining. So if they're not insisting on geo-blocking of the radio station's website, I'm not sure how you can say that their consent has been territorially limited. Now you need to unmute so I can hear you answer.
My lady, there are 2 points to consider in that context. First of all, where one is dealing with an express license, the license will have a territorial limitation in it expressed. The result of that will be that the station concerned cannot target outside of that territory. So to that extent, the minute the station starts targeting outside the territory, it's going beyond the term of its license and committing infringement in whatever other territories it is targeting. when one is considering the question for the purpose of the new public, when one is in the foreign territory, in this case one was in the UK, foreign to the relevant station, the question one asks for the purpose of UK copyright is this communication targeted at people, at a public that falls within the original authorization? To which the answer can only be no, it plainly isn't, because the original authorization was territorially limited. Now, my lady, the second answer to the question concerns those countries where the station is operating under a statutory licensing scheme or an equitable remuneration regime. And my lady, just so your ladyship understands, those aren't a rump of outliers. The US, in fact, I think the whole of North America operates statutory licensing or equitable rights regimes. Most, if not all, of mainland Europe, they're commonplace. In relation to those schemes, there can't be any question of a communication to the public in the UK falling within any prior authorization, because there hasn't been any prior authorization that's been given by the right holder at all. Now, to come back to Soulier, if in those cases the stations are operating in their territories, licensed at their domestic publics, one cannot, we submit, approach those on the basis that simply because they're on the internet, somehow rights holders must be taken to have taken them into account by their prior authorization, even though there wasn't. And the answer, my learned friend's answer, well, geo-blocking, that doesn't work because we couldn't impose geo-blocking on them because they're operating under statutory schemes. And why, in a sense, one always comes back to targeting with this. Because what the vice is here is that these foreign stations could easily be operating perfectly lawfully, let's assume we're in category 3 stations. They're operating lawfully under their licenses, whether they're statutory licenses or express licenses. But those licenses only permit them to target those territories. The minute they start targeting here, there is an infringement. And we say, my lady, that follows, and has to follow, from the Svensson analysis, from GS Media, from Soulier, because the minute they start committing an act of infringement here, by targeting here, then UK copyright is engaged, and they are targeting a public not taken into account by any previous authorization. Now, one of the points that the judge made was that it can't be a matter of what contractual terms are agreed. We submit he was taking too narrow a view, and certainly now in the light of subsequent authority can be seen to have done so. Perhaps first of all, I apologise for this. I should have taken the court to this particular passage when we looked at this earlier, but it's part of FAPL, again, behind tab 36. it's FAPL behind tab 35, I do apologise. It's a paragraph 44 on page 694. When my Lord Justice Arnold was considering whether the communication was to the new public. This was the first row case, which we looked at earlier. And FAPL contends the communications to the public rely on the reasoning in IT catch-up. I agree it's equally applicable, etc. I accept this. And then it goes on. In any event, even if FAPL had shown communication was to a new public, I consider it's clear that that requirement is satisfied, since the effect of first row's activities is to make the broadcast available to persons who are not legitimately entitled to view them either because those persons have not subscribed or because the broadcast has only been licensed by FAPL for a different territory. So one sees in that case territorial restrictions being carried through to the question that one then comes to consider for the subsequent transmitter or communicator as to whether there has whether there's a new public, whether that public is taken into consideration. And then one sees in Tom Cabinet, which was looked at yesterday, but just if the court wants to take it up, behind tab 67 of page 1829. This was the case involving the resale of e-books, and the relevant passage is the short one at paragraph 70 to 71 on page 1867. Where the court explicitly took into account the limitation on the user license for the original purchaser of the book, namely that he can only read that e-book from his or her own equipment. That's paragraph 71. And because of that term in the user license, the court held that resale constituted a new public. Now, Mr. Howe sought to get around this by saying that Tom Cabinet's not concerned with linking. That's true, but irrelevant. And second, he says that that's merely a high-level reference to an industry practice. Well, with respect, no, it's not. It's reference to a user license and its terms. And anyway, if one is thinking in terms of industry practice, nothing could be more well known than that licensing of radio stations operates territorially, and a fortiori statutory schemes operate territorially. So we submit that it is relevant and necessary in consideration of the new public test to look at the scope of the particular license granted and to see what public was taken into account, or to use the language of Svensson and the language of Raphael, what public was targeted by the original communication, or to what public was the original communication directed. And one sees in this context, and again, I won't take the court to this, but one sees this.
To the same. You say all those things mean the same. The targeting, the directly, and the taking into account. It's all the same test.
In substance, my lady, yes. What material one looks at will depend on the particular circumstances. Where one has an express license, and where the limitation concerns the territorial one, it's darned easy, and that's what we've got. Where there isn't an express license, then one might be searching around to see what one can imply, infer from the circumstances. And in some cases, like the Raphael case, you may have an express license, but on analysis, only which for example, covers a territory, but on analysis only part of that territory is targeted or falls for consideration in the particular circumstances. In our case, it's much easier because we have simply the limitation that is territorial. Just for the court's note, the language of targeting in this context, it's seen repeatedly. One sees it in Rehau, that's tab 69, page 1907, paragraphs 48, 49, and 60. That was playing televisions in a rehabilitation centre. VCast, tab 75, page 2082, paragraphs 47 and 50. That was concerned with the making of recordings of Italian television programmes. And Airfield, tab 56, page 15, 12, paragraph 72. It may just be useful to turn up Airfield, in fact, if we look at that. As I say, that's tab 56, page 15, 12. This wasn't directly concerned with the Information Society Directive. It was a case dealing directly with the Satellite and Cable Directive, and it concerned a service which provided satellite TV, and it bundled up various broadcasts into one package and then provided that to users. And it was a case where the geographical footprint covered by the licensed broadcasts was the same as the geographical footprint of the satellite service. And one sees at paragraph 72, where at page 1524, the court deals with it in language taken from its learning in relation to the Information Society Directive. And then goes on at paragraph 73 to set, 75 to set out that the communication must be to a new public. One sees that at the pre-penultimate line 75. And then the court goes on, nevertheless, that finding does not preclude intervention by other operators in the course of a communication such as that referred to in the preceding paragraph, with the result they render the protected subject matter accessible to a public wider than that targeted by the broadcasting organisation concerned. Again, one has the language of targeting there, the targeting being, the question being, who was targeted by the original licence, in effect, in this case the broadcasting organisation which granted the licence. And then the court goes on to consider, and the particular passage I invite the court's attention to in relation to this also is in paragraph 81. It's to be noted that the satellite package provider does not enable its subscribers to access the communication of a single broadcasting organisation, but brings together a number of channels from various broadcasting organisations in a new audiovisual product. The satellite package provider deciding upon the composition of the package thereby created. Accordingly, it must be found that the satellite package provider expands the circle of persons and enables a new public to have access. That, I'm not suggesting this case is on all fours, but it provides an illustration of the sort of things that can result in the finding of a new public, and it can include, in this case, the packaging up of a lot of disparate broadcasting services into one package. And that aggregation of broadcasting services can entail that one is thereby giving access access to a new public. Now, turning then to category 3 stations and to look at the particulars of this case. No consent was given. Because all of the category 3 stations were in statutory licensing or equitable remuneration regimes. So there's simply no authorization given by rights holders at all. The rights holders in those territories were not in a position to withhold or give consent. They couldn't prevent the stations providing their service. They couldn't require access controls. Now, the judge said that they should nonetheless be treated as having given a deemed consent. Now, we say that went too far because it's simply not the case. But in the result, it doesn't perhaps matter, because having found there is a deemed consent, the judge then went on to consider limitations on that, and one sees that at paragraph 137 and following of the judgment. And what he in effect found was that the deemed consent has to be seen as being geographically limited. And so, my lords and my lady, we don't entirely agree with the way in which the judge got to his result, but ultimately he got to the right result, we say. That is to say, we would prefer to put it on the basis that there's simply no relevant consent because one is dealing with statutory schemes. But in any event, he correctly, if one does treat it as a case of consent, he correctly limited the scope of that consent in accordance with the sort of considerations we see in Soulier, keeping it within its proper bounds and being limited to the territories in which those stations operated, and by virtue of whose statutory provisions they got their right to broadcast. That's all I'm going to say about category 3 stations, unless there's anything else I can say. And I was going to move on to category 2 stations, where the analysis...
Sorry, Mr. Cullen, could I just check I've understood the facts correctly? Because I'm not sure I had previously quite understood the point you were just making. You say all the category 3 stations are statutory licenses or equitable remuneration. I had understood, maybe rightly or wrongly, that some of them were licensed by rights holders, but licensed explicitly for a foreign territory only. Is that a misunderstanding on my part?
I think, with respect, my lord, I think it is. I'll be corrected if I'm wrong, but I think the position was that all of the category 3 stations were statutory license scheme, or equitable remuneration, and I think there is a finding to that effect.
So it's paragraph 118.
Yes.
So
we're looking at Belgium, Germany, Sweden, the Netherlands, and the USA, and I think they're all...
Right, so just to clarify my thinking on that, the first sentence, if you take it at face value, is actually a little misleading. One needs to understand what he says in the first sentence in the context of the remainder of the paragraph. What he actually means by this in this context is it's statutory licence or equitable remuneration. It's not consent by the copyright owner.
My lord, that's right.
Thank you.
There was no category 1, obviously UK stations. There were consensual licences, but category 3 there were none.
But do we then have any category where there's a consensual licence restricted to the foreign territory?
There isn't one in the sample stations.
So what happens about that?
Well, we say, my lord, the same result should follow. That's to say, one looks at the terms of the licence, and if there is a territorial limitation, one asks oneself, was the UK public taken into account by the grant of that licence? Answer, no, because one can see from the terms of the licence.
Well, sorry, my question was ill-phrased. Let me rephrase it. I understand your position in respect of such a case. I'm thinking about the procedural position, because I now understand that which I had not previously understood, and it's my fault, namely that we don't have a finding of the judge, because it wasn't in issue before him, as to a category of stations which are subject to consensual licenses between the rights holders and the foreign stations limited to the foreign territory.
We don't have any sample station with a consensual licence within the sample stations.
One would assume that the parties would rather not have that question left open. So what I'm going to suggest is that the parties think about that question overnight as to where you stand. I mean, obviously, this is perhaps more a question for the appellants than it is for you. I mean, the appellants are entitled to stand on their procedural rights and say, well, this is an open question and it must be decided hereafter. But on the other hand, given that we've had all the arguments on it, it might be more sensible for it to be decided now. But I just raise that as a question.
But I also raise as a point that my understanding going some way back was that the local collecting societies are only have the rights for the local territory, that the collecting society in Germany is only licensed by Warner and Sony or whatever to license people for the German territory, so they're not able to grant a license for any territory beyond their own. But that will no longer be the case, I don't know.
I think the position is, and there was some evidence in relation to this, my lady, that is true, but there are reciprocal agreements between various collecting societies which enable, in some circumstances, rights to be fed through one or other of the collecting societies.
Also, it doesn't completely make sense in a situation where they're all being simulcasted, and therefore every national station broadcasting in Germany is actually putting its stream on the internet anyway.
My lord, then one comes back to the whole issue of...
Well, exactly. Well, Mr. Cullen, I think that may be a good moment to break. You're going to move to category 2, and you and Mr. Howe will think about the questions that my lord and my lady have asked you to consider, and we'll resume at 10:30 in the morning. Thank you.